Hi, good morning. Will's on Wednesday, and we are talking about just what happens if you pass away. You die without a will. And last week we talked about if you're married and you die without a will. And today we are going to talk about if you are not married and you die without a will. What happens? Who does stuff after you pass away, and what do they do? And what happens to all of your things, and most especially what happens to your children. My name is Amy Rafeka. I am the owner of Atlanta Wills and Trust Law Group, and we go live every Wednesday here on Wills on Wednesday to share important information, especially information for women who want to protect who they love the most. Today we're talking wills. We're talking if you don't have a will and you are not married, what happens? So there is a term in the legal community, in the wills legal community, if you pass away without a will. And that term is dying intestate. And all that really means is you've never prepared a will, or you prepared a will that is no longer valid, or the court deemed it to be no longer legally valid. And we're not going to get into all the reasons why, if you have a will, a court could deem that we're going to save for another day. But if you have questions about that, please reach out. We are going to talk about right now if you've never done a will, or you've done a will and you know that you have revoked it or taken it away. So let's talk about that. Well, there's a few things that are going to happen. And again, I mentioned this word intestate. And the laws of whatever state you are in, and here we are in the state of Georgia, the law, or every single state has what we call intestate laws. And those are the laws that are going to apply to your estate, meaning everything that has to do with you after you pass away. Those laws will apply if you do not have a will. Now, if you do have a will, those laws are not going to apply. So here you have a choice. You can let these laws that someone else created with all of these decisions in it apply, or you can create a will and just completely take it out of this realm. But right now we're talking intestate laws, and every state has them, and here in Georgia we have them. They've been around forever. So they're somewhat archaic, old-fashioned, in many ways, but those laws are going to apply, and they apply in a few different ways. Most importantly, they are going to apply in the area of who receives your things if you pass away. And it comes down to a fourth grade word problem. And I know that might sound somewhat trite or somewhat silly when I'm sitting here talking about someone passing away, but really when you take a look at the laws, that's what's happening in the intestate laws. So if you pass away without a will and you fall under these laws, and then you have children, young children, then they will receive a certain percentage of your estate, and depends on how many children you have. It'll be broken up. Now, if you have adult children, it'll be broken up the same way, but they may be entitled to a little less. So let's pretend that I'm single and I have a child who is 18 years old and in college, or excuse me, let's do 19 just to make it super clean. 19 years old and in college. And then I have a 15-year-old and they're in high school still and at home. My 15-year-old will be entitled to more of my estate than my 18-year-old. And there are a lot of reasons for that. It basically comes down to how much I would have supported that 15-year-old more than the 18-year-old for longer. And let's be real though, realistically, I'm still supporting that 18-year-old and probably will for several years, but they will be entitled to less. So let's pretend that both of them are adults, that they're probably going to share equally in my estate, and most people are okay with that. Of course, you know, I want my children to share equally. They're healthy, they're happy, I have a good relationship with them. I die without a will, my children share equally. But who of my adult children will help take care of my estate? And that's the next big thing, that when you fall under this intestate law, when you do not have a will to make sure that your voice and your choices are heard, there will have to be a decision of who takes care of all the things that you've left behind. Now, you might think that my children will work it out and they'll figure out who is going to take care of all these things. And you know what? They might, but they might not. And then again, under the laws of intestacy, or these intestate laws, there is going to be a process and a decision-making process in the probate court of who is the person that should take care of all the things that you have left behind as their mother. And these things include finding all of these bank accounts, all the employers, all life insurance policies, and all of your property, and they have to do quite a bit of work. Now, I've personally been in a situation where more than one person thinks that, I see that you have a question, Jenna, I'm going to get to it just a second. More than one person thinks that they should be that person. And then the court has to decide, and the people that are stepping forward to take on that role have to sort of argue against each other. So you're going to potentially be putting your children in a situation where they may have a disagreement and they may be going against each other to take care of your estate. How long does that take? Well, it really depends. It's not a super quick process, meaning you're probably not going to go to the courthouse and have it done in a week or two. It's probably going to take several months. There are some requirements to wrap up your estate, and it depends on whether or not there are creditors of the estate. And so it can take several months, possibly 6 months, 9 months, and depending on any disagreements, especially disagreements that occur in settings without a will, and we don't know who is supposed to be doing what and who is supposed to be giving what of your things to people, there is potentially the opportunity for that to last much longer than 6 or 9 months. And so I would say, you know, on average, if it's a very straightforward and small estate and not very complicated, you could be looking again at that 6-month range to wrap everything up. But it could definitely get more complicated if there's real estate to sell, if there's a lot of personal property. So it really sort of depends on the person. But thanks for your question. So we've already talked about now, if you pass away without a will, there's 2 huge areas that are sort of left up to the laws of Georgia. Just to be super clear, there is a myth out there that the state of Georgia takes everything if you die without a will. That is not true. Your family will receive your things and your money and your property. But the big, big difference is the state of Georgia decides who gets what and how much, rather than you deciding who gets what and how much. And another thing, the state of Georgia gets to decide who's in charge of this whole process of dividing up everything. Now, I briefly mentioned in the very beginning of our talk today that if you pass away without a will and you have a child under the age of 18, there are some really big decisions that the court has to make on who would raise your child. And if you have a will, you get to voice your opinion about who gets to raise your child. And this is a really complicated topic, and we will definitely, and have addressed it in previous Wills on Wednesdays, and we'll definitely be addressing this again. But that process, which is called a guardianship process, is not something that you want your child to go through without your opinion and your choices being heard. So I implore you, if you are a mother of a child under the age of 18, even if your child's biological father is there in your child's life and is able and willing to take that child into their life, I implore you to still name who you would wish to have as a guardian in your will and in your estate plan. And there are a few big reasons why. What happens if the week before you pass away, their father also passes away? What happens if your child's biological father has some sort of illness or is recovering from something and just can't do it or can't do it yet? So there are a lot of reasons why. And there's a potential reason of that biological father may not be the best person to raise your child. They will look at your child's biological father, their natural guardian, as a potential person to raise your child. But again, you do not want your child to go through the guardianship process without your voice, their parent, being heard. And so if you are single and you pass away without a will, these big three major things. First, your money, where does it go? Who gets it? Who's going to be responsible for doing all of this? But most importantly, especially as a mother, who is going to raise your child? Those three things cannot be heard if you don't have a will. Thank you for joining me today. I really appreciate it. Thank you, Jen, for watching us here. If you are watching this live with us and have a question, absolutely drop it in the comments. If you are watching this on the replay, we do keep track and watch for comments. And so please leave a comment if you have questions about whether or not your will that you do have is valid and legally enforceable, or if you do not have a will and want to talk to us about getting one. We are here to help you. You can reach out to us at 770-508-6525, and that's here at Atlanta Wills and Trust Law Group. Thank you so much for joining me today. I really appreciated having you. See you next time on Wills on Wednesday.